His name is Ibrahim. He is 54 years old and he runs a rice distribution business in Yola, Adamawa State. He has 3 trucks, 6 employees, and a customer base that stretches from the market to the university cafeteria. He has been in business for 22 years. He has survived every economic crisis Nigeria has produced in that time. Obasanjo's reforms, Yar'Adua's death, Jonathan's dollar management, Buhari's recession, the 2016 Naira collapse. He survived all of them. He is not sure he is surviving this one. Rice that cost him 32,000 naira per bag in early 2024 now costs him nearly 90,000 naira. His customers cannot afford to buy in the quantities they used to. His trucks are running on fuel that costs 3 times what it did when he last replaced his engine. He has laid off 2 employees. He is paying rent on a warehouse from profit margins that have disappeared. Ibrahim is from the same local government area as Atiku Abubakar. He has voted for Atiku in every election where Atiku has been on the ballot. He is 79 years old in his political loyalty. He believes, genuinely, that Atiku, if given the chance to govern Nigeria, would have managed the economy better than what he is living through now. But Ibrahim has a question he asks quietly when it is just him and his most trusted employee. Is Atiku still a real option? Because something has just happened to the party Atiku is running on that Ibrahim does not fully understand. A court ordered it shut down, and then another court said wait. And October 27th is now the date on which the whole thing gets decided. What is happening to Ibrahim's political loyalty is really about whether the Nigerian legal and political system will allow a genuinely competitive 2027 election to take place at all. And the specific court battle around Atiku's party, the ADC, is the most concrete, most documented, most currently live test of that question. Before we go deeper, if you are just finding NaijaNewsWatch, welcome. This channel exists to break down what is really happening in Nigerian politics without the noise and without the spin. If that is the kind of analysis you enjoy, hit subscribe and stay with me, because this story is about to get a lot more interesting. Let us catch you up on exactly what has happened and why it matters for every Nigerian voter, not just northern APC defectors. After leaving the PDP, the party he had been affiliated with for decades, Atiku Abubakar moved into the African Democratic Congress in mid-2025. He was part of a coalition that included former Kaduna Governor Nasir El-Rufai, former Transportation Minister Rotimi Amechi, former Senate President David Mark, and others. The ADC was repositioned as the grand opposition vehicle for 2027. Then the coalition fractured. Peter Obi and Kwankwaso left the ADC and moved to the NDC, the Nigerian Democratic Congress. Obi was formally declared the NDC's presidential candidate on May 30, 2026. Atiku stayed on the ADC. He won the ADC presidential primary on approximately May 27, 2026 with 1.8 million votes. Rotimi Amechi came second with 504,117. The ADC announced the Atiku Amechi presidential ticket. And then, on June 15, 2026, 10 days ago, a federal high court judge in Abuja ordered the deregistration of the ADC and 4 other opposition parties. The stated legal basis was that the parties had failed to meet the electoral performance threshold under Section 225A of the 1999 Constitution. Atiku's response was immediate and documented. His spokesman said, Nigerians and the international community can see the level of desperation of the government of the ruling party to either have their way in the 2027 elections or destroy our democracy. Atiku himself called what happened the height of judicial rascality, because the Court of Appeal had issued a stay of proceedings order on May 22, 2026, specifically directing the Federal High Court Judge, Justice Peter Lifu, to take no further action in the case until October 27th. That order was in Justice Lifu's possession. He delivered judgment anyway. 2 days later, June 17, 2026, the Court of Appeal stepped in and halted the deregistration. The ADC got its reprieve, for now. The full appeal is scheduled for October 27, 2026. That is where we are. Now let us look at the legal architecture, because the specific rules involved here determine whether this is a legitimate regulatory process or a political operation using the courts as a weapon. Section 225A of the 1999 Constitution was introduced through the 4th alteration to the Constitution. It provides that a political party that fails to secure certain minimum electoral results, specifically winning at least 1 seat in the National Assembly or securing at least 25% of votes cast in at least 1 state in the most recent presidential election, may be deregistered by INEC. The ADC disputes that it failed this threshold. The party argues it won state legislature seats and therefore qualifies. That's the substantive legal argument that will be tested on October 27th at the Court of Appeal. But the procedural argument is equally important and may actually be stronger. The Court of Appeal issued an order in Appeal number AC/ABJ/CV/569/2026, specifically directing the Federal High Court Judge Justice Peter Lifu to stay further action on the matter until the appeal was heard. That order was issued on May 22, 2026. Justice Lifu delivered judgment on June 15, 2026, 3 weeks after the stay order was in effect. A lower court proceeding to judgment while a higher court's order directs otherwise is a documented procedural violation. It is this specific violation more than the substantive Section 225A argument that makes Atiku's legal challenge technically strong. The INEC dimension is the third element. INEC received the court order on June 15th and was directed to commence deregistration. After the Court of Appeal's June 17th stay, INEC now operates under conflicting instructions. The stay from the higher court prevails, but the practical consequence of having a deregistration order, even a temporarily stayed one, hanging over your party platform during the pre-election period is that legal uncertainty affects candidate registration timelines, party member confidence, and the operational stability of the entire electoral campaign structure. For Ibrahim in Yola, the rulebook translates into one concrete practical question. If October 27th doesn't go well for Atiku, if the appeal fails, or if procedural delays push the resolution past INEC's candidate registration deadline, is the candidate he has backed his entire adult political life going to be able to appear on the 2027 ballot paper? Now, let's go deep. This is where the political strategy behind the court battle becomes visible, and where the most important question about Nigeria's 2027 election gets answered. Let us start with who filed the suit and why that matters more than almost anything else in this story. The deregistration suit was instituted by the National Forum of Former Legislators, not INEC, not the APC directly, not a federal government agency, a civil society body of former parliamentarians. This is the detail that most coverage has passed over too quickly. A civil society group whose funding sources and political connections are not publicly disclosed filed a suit that, if successful, would remove the main opposition coalition's presidential platform 9 months before Election Day. The suit was filed in a specific federal high court registry, assigned to a specific judge, and that judge delivered judgment in apparent defiance of a higher court's order to stay the proceedings. Whether this sequence was coordinated, coincidental, or a combination of both is not something NaijaNewsWatch can confirm without documentation. What we can document is the pattern, and the pattern is politically significant. Now, here is the strategic logic behind the deregistration attempt, if it was deliberate, may have been to remove Atiku's platform and reduce the 2027 race to essentially the APC versus the NDC. But what the deregistration episode may actually produce is the opposite of its apparent intent. Think carefully about what happens if the ADC appeal fails or if delays push the resolution past INEC's candidate registration deadline. Atiku needs a new platform. The only nationally prominent opposition platform with a clean legal status is the NDC, where Peter Obi and Kwankwaso sit. If Atiku is forced to migrate to the NDC, the Atiku-Obi collaboration that private negotiation failed to produce would be achieved through judicial pressure. The deregistration maneuver, if successful, may inadvertently create the most formidable opposition configuration in Nigerian political history. That's not a small irony. That's the most important accidental political consequence of the 2027 cycle so far. Now let us talk about the specific political and financial calculations of the key players. Atiku's calculation. He is 79 years old. He has run for president 7 times without winning. This is likely his final serious attempt. For him, the ADC appeal is existential, not just politically but personally. Losing the platform at this stage means either accepting a diminished role as an NDC junior partner or accepting defeat and leaving the race entirely. Neither option is acceptable to a man who has spent his adult life preparing for this moment. His political investment in the appeal outcome is therefore maximum, which is why he has already invested $1.2 million in Washington, D.C. lobbying to build international pressure around the deregistration narrative. The APC's calculation, a divided opposition, Atiku on ADC, Obi on NDC, is the structural condition that most closely replicates the 2023 fragmentation that allowed Tinubu to win with 37%.
If the ADC is deregistered and Atiku cannot get on the ballot, the most prominent northern opposition figure is removed from the race, reducing the competition to Tinubu versus Obi, which is geographically and demographically less challenging for the APC than Tinubu versus a unified North-South coalition. Obasanjo's calculation: the former president has been the most active backroom broker in the opposition realignment. He held meetings in Abeokuta with Kwankwaso. He advocated publicly for a unified ticket. The deregistration episode is one he will likely use in private conversations with both Atiku and Obi's camps as evidence that the external threat is too serious for continued platform separation. Watch for a public statement from Obasanjo in the weeks following October 27th that either celebrates an ADC victory or pushes urgently for NDC-ADC coordination after a loss. The NDC's calculation: Seriake Dixon has built the NDC patiently and strategically. He has Obi, he has Kwankwaso, for now, despite internal tensions. A successful ADC deregistration that forces Atiku into the NDC would transform the NDC from a capable opposition platform into a genuinely national coalition. But absorbing Atiku also means absorbing his northern political networks, his financial resources,
and his demand for his senior role, all of which could destabilize the Obi-NDC configuration that Dixon has carefully constructed. The NDC's welcome for Atiku, if forced, would be complicated. The timeline of moves so far is specific and documented. May 22, 2026, Court of Appeal issues stay order against the deregistration proceedings. May 27, 2026, Atiku wins ADC presidential primary with 1.8 million votes. ADC Amaeji ticket announced. June 15, 2026, Federal High Court delivers deregistration judgment in apparent defiance of the stay order. Atiku calls it judicial rascality. June 17, 2026, Court of Appeal stays the deregistration. ADC gets reprieve. October 27, 2026, full appeal hearing scheduled. Every one of those dates is verified. Every one of them matters for what happens in 2027. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture. Let us come back to Ibrahim in his warehouse in Yola. He runs his rice distribution business on tight margins. He has laid off employees. He is paying rent from profits that have contracted. He believes, genuinely, that Atiku's economic competence would have managed Nigeria differently. He has voted for Atiku every time Atiku has been on a ballot. And now, his candidate's party has been ordered deregistered by a court that apparently ignored a higher court's order to stay the proceedings. Ibrahim does not know what Section 225A of the Constitution says. He does not know the difference between a federal high court and a court of appeal. What he knows is that something happened to the party his man was running on, and then something else happened to fix it, and October 27 is now the date that decides whether any of it sticks. What Ibrahim does understand is this: if Atiku cannot get on the 2027 ballot, if the court ruling ultimately stands, or if procedural delays push the resolution past INEC's candidate registration deadline, his vote becomes meaningless. Not because he will not vote, but because the candidate he would vote for will not be there. And in a political system where 7 governors just defected without asking their voters, and where a court delivers judgment while ignoring a higher court's order to stay the proceedings, Ibrahim is asking the oldest political question in Nigerian democracy: does my vote actually matter? For businesses like Ibrahim's, the political uncertainty of the opposition's legal battle has a specific economic dimension. A competitive election produces uncertainty for incumbents. Incumbent uncertainty produces policy caution. Policy caution in an inflationary environment can mean slower price increases on administered items, fuel, gas, electricity. If the opposition is viable, it exerts accountability pressure on the government's economic management. If the opposition is eliminated through legal maneuvering, that accountability pressure disappears, and an unaccountable government in an inflationary crisis is not a government that is incentivized to protect the purchasing power of rice distributors in Yola. The international dimension of this story is specific and documented. Atiku has hired Washington, D.C. lobbying firm Von Batten Montgomery York for a reported $1.2 million to build U.S. policy standing and counter Nigerian government narratives ahead of 2027. The ADC deregistration episode is now his most specific, most documented, most legally verifiable piece of evidence for international audiences that the 2027 electoral playing field is being manipulated. When a U.S. policymaker or a U.S. congressional staffer covering Africa asks, "Is Nigeria's 2027 election environment fair?" the answer that the ADC lobbying operation will give includes a federal high court judge delivering judgment in apparent defiance of a court of appeal stay order 9 months before a presidential election against the platform of the main opposition presidential candidate. That is a specific, verifiable, documented claim. It is the kind of claim that generates formal responses from the U.S. State Department, the European Union Observer Missions, and the ECOWAS Democratic Governance Monitoring Framework. International election monitoring bodies will assess Nigeria's pre-election environment in the second half of 2026. The judicial conduct in the ADC case, the stay order violation, the rapid court of appeal correction, the October 27 appeal will all be part of that assessment. A Nigeria that enters the 2027 election cycle with documented evidence of judicial irregularities in politically sensitive opposition-related cases is a Nigeria whose election legitimacy will be internationally scrutinized at a level higher than 2023. For Nigerians in the diaspora, particularly those from the north who historically backed Atiku, the deregistration episode is a direct signal about whether their political community's representation in the 2027 race is being deliberately reduced. The diaspora's ability to amplify this specific, documented story through international advocacy networks is one of the most potent tools available to the opposition in the months before October 27. Let me address what people on every side are getting wrong. The first misconception from Atiku supporters is that the Court of Appeal's stay of the deregistration on June 17th means the ADC is safe and the crisis is over. It is not over. The stay is a reprieve, not a resolution. The October 27 appeal will determine whether the deregistration stands or falls. If the appeal court finds on the merits that the ADC genuinely failed the Section 225A electoral threshold, separate from the procedural stay order issue, the deregistration may ultimately be upheld even if the lower court's conduct was procedurally irregular. The procedural victory of June 17th is important. It is not the end of the story. The second misconception from APC and government supporters is that the deregistration was a legitimate, routine enforcement of electoral law with no political dimension. The timing undermines this claim. The judgment was delivered on June 15, 2026, the same day the Atiku Abubakar ticket was formally announced and 3 weeks after a higher court stay order directed the judge to take no further action. Routine regulatory enforcement does not typically operate in apparent defiance of appellate court orders. The coincidence of timing, primary on May 27, ticket announced on June 15, deregistration same day, is a coincidence that deserves scrutiny. The third misconception is the most important one for Nigeria's democratic health. It is the belief, shared by some cynical Nigerians, that this kind of judicial political maneuvering is normal, acceptable, and something voters simply have to live with. It is not normal. A federal high court judge proceeding to judgment while a court of appeal stay order is in effect is a documented breach of judicial hierarchy. The fact that the Court of Appeal corrected it within 2 days demonstrates that the appellate judiciary does not consider it acceptable either. The civic response to normalizing this kind of conduct is the slow erosion of every citizen's confidence that their electoral participation is meaningful, which is exactly what is at stake for people like Ibrahim in Yola. Here is what to watch and what the signals will tell you. First signal, October 27, the Court of Appeal hearing. This is the single most consequential legal date in the 2027 election cycle. If the ruling is clear, sweeping, and delivered before INEC's candidate registration deadline, fully restoring the ADC and explicitly addressing the procedural violation, Atiku has a stable platform and the race can proceed with both ADC and NDC in the field. If the ruling is delayed or is narrow or arrives too late for INEC's processes, the practical effect of the deregistration may be felt even if the formal legal outcome is an ADC victory. Watch not just the ruling, but its timing. Second signal, whether INEC issues a formal public statement on how it will manage the conflicting orders. INEC received the deregistration order on June 15th and a stay of that order on June 17th. The Commission now operates under conflicting judicial instructions. Its public handling of that conflict and the clarity of its formal statement on whether it treats the ADC as a registered party pending the October 27 appeal will signal whether INEC is operating as a genuinely independent institution or a body that is waiting to see which way the political wind blows before committing. Third signal, Obasanjo's next public move.
The former president has been the most active and credible backroom broker between the opposition camps. If he makes a public statement in the immediate aftermath of October 27, calling for specific ADC-NDC coordination, naming the precise configuration he wants, it means private conversations have reached the point where public pressure is needed to close the deal. That statement, if it comes before INEC's candidate registration deadline, is the clearest leading indicator of a last-minute opposition merger. Best-case scenario for democratic competition. The October 27 appeal succeeds cleanly. The ADC is fully restored. Obasanjo brokers a formal ADC-NDC coordination arrangement. Both platforms compete, but coordinate state by state to minimize vote splitting. Ibrahim in Yola can vote for his candidate on a valid platform in 2027, and the judicial conduct in the ADC case produces an NJC inquiry into Justice Lifu's decision to proceed to judgment while a stay order was in effect, establishing that the rule of law applies even to politically sensitive cases. Worst-case scenario. The October 27 hearing is delayed through procedural maneuvers. INEC's candidate registration deadline passes before the appeal is resolved. Atiku is forced to contest on a smaller, less recognized platform or drops out of the race entirely. The 2027 presidential election becomes a two-platform race between the APC and the NDC, geographically less competitive, northern representation reduced, and the accountability function of a genuinely multi-party race significantly weakened. Ibrahim votes, but his candidate is not there. The long-term political impact if opposition party platforms can be legally challenged and removed from the field in the pre-election period without effective consequence for the institutional actors who enabled it is the permanent availability of this tool for every incumbent government in every future election cycle. This is not just Atiku's problem, it is every opposition party's problem, and ultimately it is every voter's problem, because a democracy in which the incumbent can shape who appears on the ballot is a democracy in name only. Let us go back to Ibrahim in his warehouse in Yola. He came into this video with one quiet question: is Atiku still a real option? Because a court ordered his party shut down and he didn't fully understand why or whether it would hold.
Here is the honest answer, Ibrahim. It is still a real option. The Court of Appeal has stayed the deregistration. The ADC exists legally as of today. October 27 is the date on which the appeal will be heard, and Atiku's legal team has a strong procedural case because the lower court judge delivered judgment while a higher court stay order directed him to do nothing. That procedural violation is documented, specific, and the appellate judiciary has already signaled it takes it seriously by acting within 2 days. But here is the honest part that does not end on reassurance. Even if Atiku wins in October, the deregistration episode has revealed something important about the 2027 electoral environment. The opposition's platforms are not safe by default. They require active legal defense, and every week that Atiku's legal team spends on defending the platform is a week it is not spending on building the ward-level structures that are the real difference between a respectable vote total and a winning one. My measured conclusion: Atiku's final stand is not over. The court gave it life. October 27 will test whether that life is durable, and the outcome of that test will determine not just whether Atiku appears on the 2027 ballot, but whether Nigeria's electoral competition in 2027 is genuinely open or structurally predetermined. That is the question Ibrahim is really asking, and it is the question every Nigerian voter from Yola to Lagos to Port Harcourt deserves an honest answer to. The question I want to leave you with is this: do you believe the October 27 Court of Appeal hearing will restore the ADC cleanly and that Atiku will be able to run on a stable platform in 2027? Or has the deregistration episode already done enough damage that even a legal victory cannot fully reverse? Drop your honest answer in the comments. If this breakdown gave you clarity on what is really going on, do me a favor. Share it with one person who needs to understand this. Like the video, subscribe to NaijaNewsWatch, and I will see you in the next one. Stay sharp.